Hi, welcome everyone. Good morning, and welcome to My HR Council and Essential Staff Care's employment law update for 2016, and really what you should know for 2017. My name is Mark Young. I'm the CEO of My HR Council, and we are very excited to partner with IAG, Essential Staff Care, not only on this update, which will be very important and very interesting, we hope, for the issues that you need to know for the rest of this year as well as into 2017, but also our partnership going forward, and we'll talk a little bit more about that. But at this time, let me introduce Nicholas Ronconi, the Director of Regulatory Compliance at IAG. Nicholas.
Well, good morning, everyone. As Mark mentioned, my name is Nicholas Ronconi, and I am the Director of Regulatory Compliance here at Essential Staff Care. I'd like to welcome you all today as we conduct a webinar on employers' responsibilities and what you, the employer, must do in order to remain compliant with the rules and regulations that govern your industry. To assist you with all these matters and more, we have created a partnership with My HR Council. They are specialists in ERISA, ACA, and other HR mandates certain to be relevant to everyone listening here today. Today's topics will include dealing with employers' obligations under ERISA, HIPAA, the IRS, among others. Now, we're just going to jump right into it. So to start us off, we do have Mark Young from My HR Council and his associates. Mark is the Chief Executive Officer with My HR Council. He has a JD and an MBA and has served as CFO and General Counsel of a number of organizations prior to joining My HR Council. Mark's organization provides on-call and online HR and employment compliance counsel to their clients. Now I'm just going to turn it over to Mark. And Mark, you can take it from here.
Very good. Well, thank you, Nicholas. That was very nice. I want to also introduce two of my colleagues here in Minneapolis, Michael Johnson, who will be speaking a little bit later, but he is a senior attorney in our office. He focuses on employment law, specifically for small, medium-sized businesses and especially staffing firms. As well, Janelle Stanton. She is also a senior attorney with our office, focusing on corporate and on employment law, also on the staffing side. And I should just mention, for those of you that know Aviante, within the staffing world, I was a CFO and general counsel at Aviante for a couple of years. So staffing is near and dear to my heart. I really do love the industry, and we focus a lot of attention on that. Just quickly on the agenda, we're going to do a quick overview of what My HR Council's services provide, and then jump into the meat of the presentation, specifically on ERISA compliance and everything that goes with that, the FLSA, or Fair Labor Standards Act, and the new overtime rules that are going into effect here December 1st. We'll talk a little bit about the pay equity developments, some laws that will affect your business here going forward in 2017. And then OSHA has been busy with several things, electronic reporting that's required, some anti-retaliation issues that they put forward, as well as some drug testing rules that do go into effect here in 2017. So just a little bit about us. You'll see big boxes here, the problem and the solution. One of the things we recognized, typically with law firms, it's very difficult to find legal support, especially for small and medium-sized businesses. The law firm business model itself, pay by the hour, doesn't provide much incentive for you to call in and get an effective and more importantly an efficient or quick answer. If you think about it, we are, as lawyers in law firms, our performance is based on the number of hours we bill, and times the bill rate. That's how we generate revenue. And so if you call in for a question and it's a simple answer, or it's one that I've answered or Michael or Janelle has answered before, the incentive to get that back to you quickly, it's difficult to reconcile that with the fact that our performance is going to be based on the number of hours we billed. We didn't think that was right, so we started My HR Council 2 years ago. And the other thing that we ran into, and my background again was spending about 20 years as in-house counsel, and also heading up a large HR department at Korn Ferry, which many of you probably know. we had many services to help us, what we thought would help us answer the kind of questions that would come up frequently on the HR side. And so we hired, ADP's HR consultants and other online do-it-yourselfers. However, they're not structured to provide legal advice. They start with, I'm sorry, we can't answer that question from a legal perspective, but we can give you some direction, and then end the conversation with, you're going to want to check with your counsel to make sure that you have a legal opinion. We, on the other hand, do give you a legal opinion, and we are staffed with employment lawyers. They focus just on employment law and the HR processes, and so you will get both the HR side of the world, but more importantly, you'll get a legal answer that you can count on and take back to your CEO or client if they're asking that question. What we think is also unique about us, you'll see underlined here on the slide, affordable. We are an on-demand legal service. We use technology, but most importantly, we do have a flat fee. So you pay a monthly flat fee. You're incented to call as many times as you want or send in an electronic ticket with questions. We have an online portal also that allows you to do it yourself if you'd like, or at least look up questions, look up forms, download forms, and then send them in to us for review. And again, no upcharges to do any of that. That's just one flat fee. So a little bit of a summary here. We do have the unlimited web, phone, and mobile sources to get a hold of our employment lawyers. It is staffed only with employment lawyers. We do have HR professionals on staff, mainly to focus on going to look at the content that gets updated daily on our portal. Also to do some marketing on, we'd have a weekly newsletter that goes out, and we're very active on social media to send out information to you so that you know all the updates. We know that there's so many changes in federal laws, but also state and municipal laws. It seems like on a daily basis that we have full-time HR professionals that their full job is just to follow those changes and to update that content. We do cover all 50 states as well as all of the federal laws. And as I talked about, our portal, we call it our Knowledge Center, is populated with forms, checklists for onboarding all the way through offboarding, and any federal and state law updates. And my favorite, I wish I would have had this when I was in-house, the pricing model is a per-month flat fee. So again, I believe it incents everyone to get a second opinion, even if it's just a quick question and a quick answer. At least you don't have to go it alone. So with that, let's jump into the meat of the presentation. So this gives you a little bit of the crossover and overview of the laws that govern plan sponsors. And just so we know, the plan sponsor, who is a plan sponsor? Frankly, it's the employer. I know there's third-party administrators out there, et cetera, that you may outsource things to, but you as the employer are the plan sponsor. And these are the specific laws that you are required to comply with. So let's start with ERISA. So ERISA is the Employee Retirement Income Securities Act of 1974. It is a federal law, and it sets the minimum standards for retirement, health, and other welfare plans. It provides protections for individuals on all of these plans. ERISA does not require employers to offer or provide employee benefits, and it offers direct financial incentives for employers to do that. So let's move on to the IRS. So many of you know the IRS, obviously, for doing your 1040s, and maybe you're involved in the corporate or partnership tax returns. But they're pretty much issued on, or pretty much focused on, what I would say compliance or penalties for noncompliance with the rules that are set forth in the IRS code. And then lastly, HIPAA, the Health Insurance Portability and Accountability Act. It requires privacy protections for health information. You probably are familiar with it if you've gone to the doctor lately, and they seem to always have on the clipboard a 15-page HIPAA document that you have to read, sign, and put your initials on. Hopefully, a few of you have read it all the way through and can interpret that. If you have, please give me a call, and you can be one of our lawyers. But it does apply to healthcare providers, and the health plans itself includes a lot of things, but for purposes it applies to employer-sponsored health plans itself. So just, again, a quick overview, but these are the laws that govern you as the plan sponsor. Nicholas, anything you'd like to add on that?
Maybe just one little thing. With regard to plan sponsors, generally being the employer, I just want to say there are certain situations where the employer can also be the plan administrator as long as they haven't designated those duties to another entity, such as a third-party administrator or something like that. It's just something that comes up a lot of times in these documents, especially under the ERISA disclosures. They'll speak of a plan administrator or a plan sponsor, and I think a lot of the times the employers aren't really quite sure who that is or who they are in that situation. So just keep in mind that if you haven't contracted with another entity to direct your plans, you may be the plan administrator as well as the plan sponsor.
Yes, perfect. That's a great clarification. Yes. All right, let's jump to what I think is maybe the easiest of the three, so we'll build to this. So the IRS, we talked a little bit. Really, they set rules and penalties for non-compliance, and they have various service centers and send out various IRS auditors to make sure that we're following those rules. So things like like I said, the 1040 in your partnership or corporate LLC returns, but also your Form 5500, and we'll talk a little bit about that also as we get to ERISA and a couple of other requirements. The IRS, if you get tax benefits if you follow the rules, and you lose them if you don't. It's pretty straightforward. A couple of just highlights: do not discriminate as it relates to your plans. That is one of the areas that the IRS has many rules and penalties, top-heavy plans, etc. But discrimination is one of the things that they really focus on in terms of non-compliance. And the other is you do have an obligation, COBRA, FMLA, an obligation to continue benefits under certain circumstances, and the IRS is really the heavy as it relates to those issues. From a HIPAA perspective, the obligations, as we talked about, it does protect personal health information. HIPAA performs certain functions or activities that include creating, receiving, maintaining, or transmitting personal health information on behalf of a plan administrator. And that includes things like claims processing or administration, data analysis, processing, or the administration of that, utilization, review, and quality assurance, and certain patient and safety activities. Probably from a working perspective, one of the things that you need to be aware of, and certainly this relates more to the health providers themselves, but you do have to provide notice of privacy practices. Geez, let me pause here. God, I'm all over the place. So next, let's talk a little bit about the HIPAA obligations. As we talked about, HIPAA, the purpose of HIPAA is to protect personal health information, or PHI. It's also to provide notices of privacy practices, again, to give the plan participants information to know what information cannot be disclosed. It also allows participants to request that disclosures of their personal health information be restricted. It allows them to request that alternative methods be used to release their PHI, to to inspect and obtain copies of their personal health information or amendments to those, and also request details of all disclosures of their personal health information going back a total of 6 years. So again, this has been in place for a couple of years now. It is typically handed out at your doctor's or at the clinic, and again, it's heavy on making sure that personal health information isn't disclosed unless the participant agrees to that. Let's jump to ERISA. So as the title says, what is it, first of all? It is the Employment Retirement Income Security Act of 1974. It does set minimum standards for plans, and it provides protections to plan participants. It governs all welfare plans, so many people think of ERISA and health plans, but it also covers everything from retirement and 401k pension, dental, vision, life insurance, long and short-term disability. And most importantly, why should you care? The fact of the matter is it requires disclosure of financial and plan information to the plan participants. It establishes standards of conduct for plan fiduciaries being those plan administrators, i.e. the employer, and provides remedies and access to federal courts to the extent that the plan administrator or plan fiduciaries don't follow what's in ERISA. ERISA has certain obligations. First of all, and we'll talk about this a little bit more in the next couple of slides, it has to provide certain information about the plan to those participants. It does impose a fiduciary responsibility for managing plan assets, and that is a big issue. There a lot of lawsuits on that. You know, hopefully that's not something that you're in the middle of or that becomes an issue, but I know that is a lot of case law around that. It does require a grievance and appeals process for participants. So for things like we dropped coverage or not covering certain illnesses or certain visits, again, it has to include, or ERISA requires that we include a grievance and appeals process. It does also give the participants the right to sue. You know, under ERISA, they added that as an obligation. And relative to the fiduciary responsibility for managing plan assets, it also, under ERISA, you have an obligation to carry a fidelity bond, again, to protect the assets that are in the plan as a plan fiduciary. Let's talk a little bit, probably more of the administrative side and the things that most people struggle a little bit with in terms of just trying to find a good list of information. And frankly, as lawyers, this is where we spend a lot of time answering questions on not only what needs to be disclosed, but how does it need to be disclosed to the plan participants. So under ERISA, you have to have a plan document. You also need to have a summary plan description, and we'll talk a little bit about how that differentiates. They're somewhat similar in that they contain some of the same information. However, ERISA does, under summary plan descriptions, or SPDs, require you to write the plan document or the information contained in the plan document in more of a reader-friendly, plan participant-friendly manner. And then it does have things like grievance processes, et cetera, that sometimes are not in plan documents. You also have to provide summary of material modifications to the extent that the plan has those or makes those changes. That usually happens on an annual basis. You also have to file Form 5500. The DOL, the Department of Labor, requires that. Form 5500 is filed through the IRS, and it's a pretty involved IRS form requiring a lot of information, financial information as it relates to the plan, but that's done annually. You also have to publish a summary annual report that typically goes with the 5500. And then there's a few other miscellaneous documents that have to be disclosed to your participants, like a summary of your benefits, as it relates to the plan documents or as it relates to when someone signs up for the plan. So again, a lot of information that has to go out, and frankly, a lot of information that goes into these reporting documents and that. But I'll leave it at that. Maybe Nicholas, do you have anything that you would like to add on this slide, perhaps?
Not on this slide. Maybe the next one.
Okay. Yeah. So let me just jump to the next one. So as you remember, the second one that I tried to differentiate between plan document and summary plan description. Again, the summary plan description that we'll talk a little bit about the production and delivery. So let's start off with many employers do have multiple ERISA plans. I talked about this a little bit before: vision, dental, retirement, life, as well as your health plan, and short and long-term disability. You have to make sure that all of those ERISA plans have SPDs. You have to ensure that all SPDs and other docs are delivered to plan members within a certain period of time, and that varies, but we can talk about that. And it is the duty of the employer to provide to employees, and it's not the TPA or the insurance company's duty. Ultimately, it is the employer's duty to make sure that that information gets provided to the employees or the plan participants. And then
now I'll just jump in here for a second, Mark. I'm sorry. Along those lines of delivery and who's going to deliver those documents, I think this is a good point to jump in here and say, everybody listening to this webinar has an agreement with PAI. It's their admin agreement, and under that agreement, the employer has, I guess, checked the box where they take on the responsibility of distributing the SPD and creating the SPD for their enrollees, and that is for the MEC-only plan. PAI will deliver and distribute a summary plan description on the indemnity plans and major medical. And sometimes there's some confusion as to why they don't do it for the MEC. The reason being is that the admin agreement that you all signed has a section in there where you did take that responsibility for the MEC SPD. And I just wanted to make that distinction because I think some confusion arises along those lines as why are we getting it on the MEC? Why aren't we getting it on the MEC? But we do get it for our indemnity and our major medical plans.
Great. Yeah. Very good. Good clarification on that too. And maybe I'll add to that. The good news is, because many people say, "Oh, geez, now there's another SPD that I have to come up with." You can coordinate SPDs for multiple plans into one document. It's called a WRAP SPD, or WRAP Summary Plan Description. It is a document that we do put together as part of our monthly service, so we're happy to do that. What we find with most clients is, while they may have a health and welfare plan that has an SPD, maybe with the MEC they don't. Typically with dental and vision and some of the other plans, very often they are not ERISA compliant, and they'll actually say that in the plan document. They don't have an SPD that's delivered. And so one of the things that we do, as I said, include into our service, and it's kind of a belt and suspenders, but you really want to make sure that you have this in place. The first thing that's going to happen is if the Department of Labor comes knocking and says, we want to do a review of your plan documents and of your compliance of ERISA and HIPAA, et cetera, when you can put a WRAP document that covers all of your ERISA plans, and you drop that down, a 100-page thud factor of your plan documents with an ERISA WRAP on top of it, what that does is it kind of gives the agent from the Department of Labor that, oh crud, this isn't going to be a big audit on that side. Maybe they'll look at something else within your company, but from the ERISA compliance standpoint, when you do have those documents all nice and wrapped up in an ERISA compliant WRAP document, it really does take the burden away from you and the worry, if you would, on a Department of Labor audit.
Definitely. This is Nicholas. I'd just like to add to that a little bit. Yeah, the RAP document, the RAPs are just great all around because they encompass all the welfare benefit plans under ERISA into one plan. And I think one of the biggest and nicest benefits of all that is you only have to file one Form 5500, whereas if you do these all separately, you need separate filings for the 5500 on all of those.
Yeah, that's correct, and that's huge. And Nicholas, you and I joked about this a little bit pre the webinar here. My first job out of school I was a CPA to start before I went to law school, and the first thing I did and the first thing accountants do is you do 5500s. They are long, but they're not as difficult perhaps as some of the corporate tax returns, and so you have several 24-year-olds that are in the 5500 department, if you would. And as you said, if you have 4, 5, 6 plans and you're doing 6 5500s, it's not cheap. They're $2,500 to $5,000, $6,000 per form. So, just by using a RAP document to pull that all together and having one 5500, not only is it cost effective, but then of course, there's less time, there's less information that you have to be sending into your CPA firm to get all these things done. And so it really is a nice step to really be effective and efficient as you get to year end.
Yeah, agreed. And just one more point with the 5500 reporting. Well, I'm sure you were sitting in a windowless basement, right, with all the 5500 other CPAs at that time. So you
Absolutely.
Okay, but with the 5500 reporting, late filings can be a problem as well. And I know that the resulting fines can be pretty high, and I believe they run $1,100 per day. Is that correct, Mark?
That is correct. Yeah. Yeah.
So as that is a high number. So you want to make sure that if you had a multiple benefit plans and it was all under one RAP, and you had to file one 5500 form, you can see the benefit right off the bat in doing something like that.
That's correct. Yep. Good point. So let's just talk briefly about risks of not having a summary plan description. So there is not a fine per se for not having an SPD. As I talked about, I think where either having the SPD or having a RAP document, where it really comes in handy is really getting the thud factor, I like to call it, but really to be able to deliver documents when either the Department of Labor, which is upping their staff and frankly upping their random audits, if you would, or if you have a plaintiff's attorney's firm, usually from a plan participant where they're either disgruntled or something happened, the first thing you want to be able to do is deliver really concise documents. That's the best way to kind of get anyone to go away. When you don't have those documents, then they can poke holes in just about anything that you've done. The benefit lawsuits, excuse me, let me just talk first about the fines for there are fines for not providing SPDs upon request. So if a plan participant requests a paper form of a summary plan description, you do have to deliver that. There are fines for not being able to do that, but again, not a fine per se for not having an SPD. Let's talk about Department of Labor audits. So those are on the rise, especially now due to the ACA, and we'll wait and see to the extent in which Trump is going to change that or repeal that or amend that or whatever. But as I talked about, the DOL has probably tripled the size of their staff. And back many years ago when I was in employee benefits and doing these 5500s, et cetera, it was unheard of that the DOL actually came to people's offices. That is not the case anymore. Again, not being able to provide an SPD, it's just an auspicious start to an audit, and it's likely going to lead to the increased scrutiny by the DOL, and it probably increases the depth and breadth of the audit. So again, probably the best start and the best way to reduce the time that the Department of Labor auditors are in your office, is to make sure that you do have the right documentation. And one of the things, you know, we want to just point out, and it's bolded here in red, it's never too late to provide that. So again, there's not a penalty for not having an SPD. If the Department of Labor does come in and you have now a document in place, they're not going to go back and say, you know, did you have that in place in the last 5 years? So if you're sitting today and you're not sure if a couple of your plans have the right documentation, again, let's go with the RAP and just make sure that those things are in place here going forward.
Yeah, can you just go back one slide? I just wanted to add a couple details here. So as Mark said, there's not a fine for not having an SPD. However, if they are requested, the delivery requirements are this. For ERISA requires that SPDs be distributed to covered participants within 90 days after becoming newly covered by a plan, or within 120 days of a new plan being established. So that said, if you got audited in that time and you didn't have a plan to hand them, and an SPD to hand them, and they wanted to do a comparison between the plan document and the SPD to see if there were any inconsistencies or such, the fine, I think, could be $110 per day for every day that there wasn't an SPD created. So, you know, these fines can get up there, and it's just something you don't want to have to deal with. And this is, you know, one of the reasons we're doing this today is to inform everybody, because we understand that, I mean, these are huge pieces of legislation with, you know, so many components. But to keep everybody compliant is really why we're here, and to alert everybody who's not aware of these situations, where these things can go. I just wanted to add that. And when we say not too late, what we're really saying is, you know, even if you're going to get fined, each day you actually have a plan in hand, you mitigate, you know, your potential penalties. So, you know, if you had one that's 10 days late, your fine is going to be, say, $1,000 or $1,100 versus, you know, having a year. You know, if it's a year late, you know, just do the math on $110, you know, a day. So not too late means, you know, ability to mitigate potential penalties and losses in the future.
Absolutely, perfect. So last slide on ERISA. A lot of stuff going on with this. Just in summary, again, the ERISA, it does set the minimum obligations a plan must follow. The requirements for summary plan description deliveries to covered employees, as Nicholas talked a little bit, as well as COBRA participants, within 90 days after being covered, within 120 days if it's a new plan. And then one of the interesting one I thought was a newly updated SPD every 5 years. And that's, I don't know if people have hit that yet or not, but they kind of probably snuck that into the law. Summary plan descriptions can be delivered by electronically. It does require consent from the plan participants. They have to check a box on the enrollment form. So you want to make sure that that's both blinking lights and highly in bold, and then also, you know, you can point that out to your plan participant or your enrollee to make sure that they sign off on that, so that they don't get a 50-page or 75-page document. And then, you know, we've pounded on RAP document, but it's a great solution nowadays for use with multiple plans. So with that, let me turn it over to Michael Johnson to talk a little bit more about the FLSA, otherwise known as the new overtime law that's going to go into effect here shortly, December 1st of 2016.
Thanks, Mark. Thanks, Andrew. We're just going to move kind of quickly through this. So as many of you know, earlier this year the Department of Labor announced some changes to the Fair Labor Standards Act regarding overtime and the exempt and non-exempt classification of employees. It's going to have an effect really on just specific areas. It's the white-collar exemptions of the exempt employees, which are the administrative, professional, and executive areas. And really what it boils down to is if someone is exempt, they are not required to be paid overtime. If they are non-exempt, they must be paid overtime for all hours worked within a work week. And what's looked at as to whether someone is exempt is the duties test and the salary test. That's some information that we have as part of our service where we can help employers evaluate employees. This rule change is coming up on December 1st, and really what we're going to be talking about is some next steps that you can potentially take to make sure that you're compliant. What you really want to do now is you want to evaluate your exempt employees, first off, to see if they're going to meet the new salary level test. If they're not, you've got some other options. Would you reclassify them as non-exempt and convert them to hourly? Well, if you do that, you're going to have to make sure that you've got a system in place to track and record their hours. Secondarily, would you prohibit overtime if you make a move like that? If you're going to go down that road, you're going to want to put a written policy in place regarding overtime approval and after-hours work, use of devices, things along those lines. Another possible option is to readjust salaries downward, doing the math to figure out the number of regular and overtime hours that the employee works to kind of keep your outlay the same as it is now. Several employers that we have talked to are doing exactly that. That's the step that they're taking. And then finally, sometimes people are looking at increasing the salary to keep them exempt. It was a significant jump from $23,660 annually to $47,476. If you're going to look at moving someone's salary to keep them exempt, you'll want to do that only if they're going to meet the duties test. And as we discussed, to be exempt, you've got to meet that salary test and the duties test. Janelle now is going to talk about some developments with equal pay.
All right, thanks, Michael. So another area of the law that continues to develop here are equal pay developments. So one of the major things that's on the docket is these new requirements for EEO-1 reports for employers with more than 100 or more employees or federal contractors with 50 or more employees. The EEO-1 is now going to require employers to submit pay data. The goal of that is to help eliminate pay disparities between men and women and also workers of different races. The data is going to be pulled from employees' W-2s and reported in pay bands being predefined salary levels. Essentially, employers that are required to submit an EEO-1 at this point are not required to submit that pay data, but that is one of the areas that will be changing. There's also several states that have more stringent pay equity laws, and as you are familiar with employment law, if a state provides more employee-friendly provisions, then that state's laws will trump federal law in that area. So far this year, some of the states we've seen, California, New York, Massachusetts, and Maryland have passed new laws granting more protections to essentially lowering the bar for an equal pay lawsuit, making it easier for somebody to bring an equal pay lawsuit, changing how equal pay laws are analyzed, requiring employers to justify pay differentials. There's been some new recent legislation regarding salary history prohibitions. So Massachusetts now forbids companies from asking job applicants about salary history. Based on the fact that previous salaries are often used to establish current pay levels, and that can end up locking in women and minorities at lower salaries. So while they're the first state to do so, with current trends picking up, it's really not something that would be a surprise to expand to other states. I have the Paycheck Fairness Act on this slide as well. It's currently stalled out. It would add some further protections to the Equal Pay Act, such as prohibiting employers from retaliating against workers who share wage information. It is seeming to be stalled out in Congress at this point, but could be something on the horizon to keep an eye out for. So some of the next steps here for employers in the pay equity realm, even if your states where you have employees haven't passed some of these more stringent pay equity laws yet, like I said, this is kind of a hot button issue and it seems to be spreading. So I would recommend that employers conduct internal pay equity audits to see if there's any differences in how different classes of employees are paid. If you do find there are disparities, there can be legitimate reasons for the disparity, things like seniority, systems that measure earnings by quantity or quality of production, level of skill, that type of thing. If there's still an unexplained wage disparity and there are no legitimate reasons, you've got to fix it. A primary way to resolve that is to increase the pay of those that are underpaid. You could create a new job title or classification. I'd be wary of that. You need to make sure that there's relevant business factors behind the new job classification to warrant that pay difference. Otherwise, you could be running afoul of those pay equity laws. And again, you want to make sure that policies about salary guidelines are clear and communicated to the decision makers in your company. Maybe putting in place additional layers of approval for what salaries will be offered, updating handbooks to remove prohibitions on employees disclosing their compensation, making sure there's retaliation protections in place, all the way up to modifying application forms and interview questions to remove inquiries about salary history. So like I said, even if it's not the law in your state, getting in front of this trend really could save your company in the long run.
Thanks, Chanel. That's perfect. And I'll just add, along with pay equity, there's several laws that we're not even touching on, and many of you may already know some of this in terms of, especially with the staffing firms, doing background checks, being able to ask about previous felonies and that, the old ban the box rules, or not old, the new ban the box rules that are now up to 24 states. We're seeing one of the trends we're seeing with our clients here is the old applications that people used, whether it's staffing firms, restaurants, et cetera, where they have mass amounts of people coming through and being interviewed. There are so many state and federal laws, but especially the state side, of questions and things you cannot ask until you've given a conditional offer. And with staffing firms, that would mean either getting into their database or actually sending them out on assignment. So you want to be very aware of that. If you haven't had your applications updated, we talk about the employee handbook too. Those are two things that just need to be almost a fluid document and being updated all the time, because each time I give a speech, which now happens to be a couple of times a week, I have to look to see if another state has passed a ban the box rule or things like that. Just one more slide, and then we'll kind of wrap up and just kind of give an overview of again kind of next steps. But OSHA has been very busy. A couple of things to just take away from this slide. OSHA does now, they've become more involved in making sure that employees are not blocked or somehow not discouraged from reporting injuries. This is relevant, especially with staffing firms that, we've heard things about joint employment, that if you send out a temp over, out to a manufacturing plant and they're injured on the job, there are requirements that site has to make sure that they are filing with OSHA those accident reports. One of the responsibilities we believe you have as a staffing firm is to make sure that those procedures are in place. And it's not enough to just ask a quick question and just assume it. You really do have to kind of look into, do they have a process to make sure that your employees, the ones that you send out as staffing to those sites, are in fact not discouraged to file potential injury reports. On top of that, where the law is going here now in 2017 is to discourage, actually to prohibit sites from being able to post things like 250 days without an injury, because that discourages employees from bringing an injury report forward. So we have seen a swing of the pendulum over to a more pro-employee, more employee-friendly type sets of policies. And so you're just going to want to make sure, again, as the employer, that those things are in place, even though, again, they're off-site. And last but not least, drug testing. So the drug testing policies used to be, and there are some areas of the law that, like truck driving, where the DOT is involved, where post-accident there's an automatic drug testing, but now the OSHA has gotten involved in post-accident drug testing, and it's no longer appropriate to have just a blanket statement or a blanket policy that allows for drug testing after any accident. There are some rules now in place or going into place here in 2017 that require that there be a link between the accident and a reasonable inclination that the use of drugs or the intoxication was the cause of the accident. And so no longer can you just have a blanket policy that drug tests everyone after an accident. So again, you're going to want to make sure that those are updated in your handbook, and that you have a better understanding of not only what you do potentially internally, but also what's going on in those client sites where you're sending employees out. So last, just kind of in a summary, 2017, what I would do if I were worried about HR running a business, or I was the head of HR in a company. Have a plan and process to draft and deliver, as Andy talked about, the many required ERISA-compliant plan docs. A lot to do there, but again, with the wrap document and that, we can certainly help out to expedite that process. If you haven't had, I always say, maybe in the last couple of months, certainly in the last 6 months, if you haven't updated your employee handbook, with the overtime laws alone, there needs to be an update to your handbook. This now has become a fluid document. This isn't a once every 3 years. Nicholas talked about it's many thousands of dollars to go to a law firm to have an employee handbook. It's unfortunate because it isn't a static document anymore with the state changes, or if you open another location or you have employees in other locations, you have to amend that document to make sure that you're including those specific state laws, because there are differences. We joke about Minnesota and Wisconsin. There are differences by crossing the river, substantial differences in employment laws, and if you're operating in both states, you need to make sure that you have an employee handbook that attends to the laws in both of those states. In addition, for staffing firms, you have an internal set of policies that at times, and a lot of times, are different from those of the temporary staff that you send out. You need to have a document for both of those two different sets of employees. And then you have processes in place to track all of these new rules that we talked about, whether it's the EEO filing and the pay bans and that are coming into place. So there's sick pay laws that are coming into play in different cities and states. Many of you have either gotten updates from the ASA on those, or you'll see those if you're reading the paper every day. And then make sure that you have had some recent management training on termination rules, FMLA. That's where we're seeing dozens of calls a week on employers that are getting caught up on, oh, I was supposed to give this person 12 weeks off for family medical leave, and we weren't tracking that, or my manager out in a different location wasn't sure of what the rule was, and there wasn't training in place to make sure that we capture those things. So a lot to do. I know it's overwhelming, but I'm going to turn it over to Nicholas and let him tell you a little bit about how we think, again, as we talked about early in the first couple of slides, how we think we've put together a very aligned and cost-effective way to get to some of these compliance issues and help you out as we go into 2017.
Not going to do anything about your checklist, right? You're basically saying going back to you, Nicholas, correct?
That's correct.
You're not saying that. Okay. And providing such helpful information on to our clients. Just want to let you know we'll be fielding some questions in a few minutes, so don't leave just yet. I want you to know that we at Essential Staff Care and my HR Council hope this webinar has provided you with the information you'll need to be in compliance with all the rules and regulations affecting your business, but most of all to help you in avoiding potential penalties in the future. So if you're interested and you have any questions regarding this presentation or want to learn more about my HR Council services, please contact Essential Staff Care representative today at sales@essentialstaffcare.com, and they'll be happy to answer any of your questions or get you registered quickly, or maybe answer some ancillary questions you may have. And now, just I'd just like to speak about. Mark's too modest to go into this, but it's very important that we understand what we're talking about here. We're talking about having a full-service law firm, especially that deals specifically with what you do, your employment law, your HR, your ERISA obligations, all the things we spoke about today, and even more that we haven't gotten into. And for $500 a month, I think you'd be hard-pressed to find any lawyer who's going to be able to match that price. Just having any one of these documents drafted, Mark and I both know that an SPD or a welfare benefit plan, something that includes your pension or your 401k, these documents are very complex and easily run between $5,000 and $10,000. So that's just for one document. So you also have the ability to call or write in 24 hours a day, 7 days a week, with a question that will be answered the next day. And you have online, telephonic representatives being able to help you who are also attorneys 7 days a week, or 5 days a week from 7 to 7. Again, that's also unheard of. So you basically have a lawyer on call. And I just wanted to say that we think we've really negotiated a great price here. We think it's a great service for everyone, and we just want you to be able to take advantage of this and stay in compliance. And we want everybody to be safe and have a profitable year now and in the future. So thank you very much, everybody.
We really do appreciate it, and we appreciate the partnership here. Hopefully everyone got a nugget or two of information that is going to be very helpful, and we didn't scare anybody off. Again, we do believe we put something together that really does help. Let me just get a little bit clearer too on, we talked a lot about the ERISA and employee benefits, and because there just is a lot of information there, but just so that you leave with understanding what our monthly service does cover. As Nicholas talked about, we're available 24/7 electronically, and for the most part, with maybe the exception of 2 or 3 in the morning, you're going to have one of our employment lawyers responding to your HR issues. We do everything, as you said, from drafting SPDs and RAP documents. We review HR policies. One of the first things we do with our clients is have them send in their employee handbooks, and we know with staffing you have an internal handbook and a handbook for your assignees, if you would, or your temp employees. Very important that we have those differentiated. We do find a lot of clients that don't have both, and frankly don't have their policies written down as clearly as they want to maintain them, and then it becomes very difficult after the fact to either terminate an employee or discipline them if it's not in the employee handbook. We provide guidance on disciplinary actions, layoffs, terminations. Terminations being one of the biggest ones that people stumble on, especially now with the advent of the Family Medical Leave Act and all of the different rules under the ADA, the accommodations that are needed for disabled people, etc. We do look at the interview policies and procedures. We give recommendations. Interview questions, what's sort of right and wrong to ask, are on our portal. And I think very important, that seems to be where a lot of interviewees or interviewers stumble. And then background checks. There's a lot going on now. Things from ban the box, states that you can't ask felony convictions before you've had a conditional offer, before you've given a conditional offer, and things like automatic drug testing after, as we talked about with OSHA, after an accident. And so a lot of attorneys coming out, the plaintiff attorneys coming out of the woodwork, looking for opportunities for things that staffing firms, especially where there's thousands of employees or thousands of W-2s that are produced every year, a lot of interactions that happen with employers and employees. And so in order to have something that is really conclusive and gives you a chance to be fully compliant on a daily, monthly, and annual basis, we believe the best way to do that is just to have a service, a one flat fee, an online, on-call, basically law firm that focuses on this that you can get a hold of when you need it. So again, thank you so much from IAG, Essential Staff Care. Nicholas, thank you so much. And thank you everyone on the phone for bearing with us. A lot of information, and we look forward to being able to earn your business.
Equally, thank you everybody. We'll be in touch as more information comes down the pike too, so stay tuned for follow-up webinars.